Welcome back to SCOTUS Oral Arguments and Opinions. Thanks for joining me after the blockbuster end to this Supreme Court term. In today's episode, I'll share insights from last week's final 9 opinions, analyze the methodological patterns that emerged throughout the term, examine the court's statistical profile across all 61 cases, and then take a deep dive into Justice Barrett's fascinating approach to statutory interpretation in Trump versus CASA. Finally, we'll discuss the June 30th, 2025 order list, where the Supreme Court agreed to take 7 major cases that could reshape fundamental areas of American law, including a billion-dollar copyright battle over internet piracy that threatens to cut off millions from their internet service, and a campaign finance showdown that could determine who really controls political party spending. These aren't your typical technical disputes. We're looking at cases that strike at the heart of our digital economy, political system, and criminal justice, promising landmark rulings on everything from whether you can lose your right to federal court by missing a deadline by one day to whether criminal defendants can escape consequences by simply going into hiding. Let's turn our attention to last Friday. 9 opinions from last week closed out what proved to be a remarkable term. I mentioned this on Friday's podcast, but last week went out with a bang. Throughout the final weeks, when the court issued 4, 5, and even 6 decisions in a day, the clerk's office posted most cases within minutes of their announcement. But Friday was different. The cases trickled out slowly, creating an unusual delay that had court watchers checking and rechecking the website. Mark Walsh's informative piece on SCOTUS blog explained the reason. The justices, Justice Sotomayor in particular, read lengthy dissents from the bench. Walsh captured how tense the atmosphere became as she delivered her pointed criticisms. Reading those barbs now, I can only imagine the discomfort that filled that courtroom. I also didn't realize until after recording that the Supreme Court punted on Louisiana versus Calais. I found it odd that no opinion appeared, but only learned later that the court had relisted this case for future consideration. Let's start with last Friday's cases, then move to last week's cases overall, then look back at the entire term. Here are the key patterns from the final week's decisions. June 27th, the conservative finale. All 5 June 27th decisions split 6-3, creating a remarkably uniform voting pattern. Conservative justices dominated the opinion writing, authoring 4 of the 5 majority opinions. Justice Kagan provided the sole exception, writing for the majority in FCC versus Consumers Research. Chief Justice Roberts maintained his coalition-building approach, joining all 5 majority opinions while avoiding any concurring or dissenting positions. The dissenting blocs followed predictable patterns. 3 cases featured the familiar liberal triumvirate in dissent, while the remaining 2 cases saw unusual conservative fractures with Justices Thomas, Alito, and Gorsuch breaking ranks. The court's approach to lower court decisions was decisive, reversing 4 cases while affirming only 1. Opinion writing duties spread evenly, with each justice authoring exactly 1 majority opinion. Justice Sotomayor emerged as the principal voice of dissent, writing 2 lead dissenting opinions, while Justices Thomas, Kagan, and Gorsuch each contributed 1 dissenting opinion. June 26th, a more fractured portrait. The previous day told a different story. 2 opinions split 5-4, while 2 others divided 6-3, suggesting deeper disagreements on these earlier decisions. Liberal justices dominated majority opinion writing on June 26th, authoring 3 of the 4 decisions. Conservative justices managed only 1 majority opinion. Chief Justice Roberts again joined every majority opinion and avoided separate positions, maintaining his preference for consensus building over individual expression. Dissenting coalitions varied more dramatically. 2 cases featured the standard liberal bloc in dissent, but the remaining cases produced unusual conservative combinations involving Justices Thomas, Alito, Kavanaugh, and Barrett in various permutations. The court showed no mercy to lower court decisions, reversing or vacating all 4 cases. Opinion assignments again distributed evenly, with different justices writing each majority opinion. Justice Alito took the lead on conservative dissent, authoring 2 principal dissenting opinions. Justices Sotomayor and Jackson each contributed 1 dissenting opinion, while Justice Thomas added a separate dissent for additional emphasis. Let's look at the year as a whole. This term, the Supreme Court decided 61 unique cases. Looking at case dispositions, the court overwhelmingly reversed lower court decisions. Nearly 45% of cases were reversed and remanded, while another 17% were vacated and remanded. Only 22% of cases were affirmed, with an additional 3% affirmed and remanded. The remaining cases included 5% dismissed as improvidently granted, 3% reversed outright, 3% relisted, and 1 unique disposition. Applications for partial stays granted, representing the Trump versus CASA universal injunction case. Turning to voting patterns, the court showed remarkable consensus in many cases. 26 cases were decided unanimously, 9-0, representing 43% of all decisions. Another 4 cases split 8-1, 10 cases split 7-2, and there was 1 case decided 8-0. However, the court was deeply divided on major constitutional questions, with 12 cases decided 6-3 and 6 cases split 5-4. There was also one 5-3 split and one 4-4 tie. For majority opinion authorship, the workload was distributed remarkably evenly across the justices. 4 justices each authored 7 majority opinions: Justices Thomas, Kagan, Kavanaugh, and Barrett. 3 justices wrote 6 majority opinions each: Chief Justice Roberts, Justice Alito, and Justice Gorsuch. Justices Sotomayor and Jackson each authored 5 majority opinions. Additionally, 5 cases were decided per curiam. This shows the court maintained balanced case assignments despite ideological differences, with the range spanning only 2 opinions between the most and least prolific authors. Beyond majority opinions, the justices wrote numerous separate opinions to express their individual views. For concurring opinions, Justice Thomas leading the way at 12 concurring opinions. Justice Sotomayor wrote 7 concurrences, Justice Jackson authored 5, and Justice Kavanaugh wrote 4. Justice Alito, Justice Gorsuch, and Justice Barrett each wrote 2 concurrences. Chief Justice Roberts and Justice Kagan authored no concurring opinions this term. Dissenting opinions totaled 36 across the term, showing significant disagreement on key issues. Justice Thomas and Justice Jackson tied for the most dissents at 8 each. Justice Gorsuch authored 7 dissents, while Justice Alito and Justice Sotomayor each wrote 4 dissenting opinions. Justice Kagan authored 3 dissents, and Justice Kavanaugh and Justice Barrett each wrote 1 dissent. Chief Justice Roberts authored no dissenting opinions, reflecting his tendency to stay with majority coalitions. Looking at how justices joined others' opinions reveals interesting alliance patterns. For majority opinions, Chief Justice Roberts joined 59 majority opinions written by others, the most of any justice. This reflects his role in building consensus. Justice Kavanaugh joined 57 majority opinions by others, Justice Barrett joined 54, and Justice Kagan joined 51. Justice Thomas and Justice Alito each joined 47 majority opinions by others. Justice Sotomayor joined 45, Justice Gorsuch joined 47-42, and Justice Jackson joined 41. For concurring opinions, Justice Thomas was most willing to join others' concurrences at 21, followed by Justice Jackson at 12 and Justice Sotomayor at 11. Justice Barrett joined 10 concurrences, Justice Kavanaugh joined 9, Justice Alito joined 8, and Justice Gorsuch joined 6. Justice Kagan joined 2 concurrences by colleagues, while Chief Justice Roberts joined none. Dissenting coalitions showed Justice Jackson most frequently joining others' dissents at 17, followed by Justice Thomas at 14. Justice Alito and Justice Sotomayor each joined 13 dissents by others, Justice Gorsuch joined 12, and Justice Kagan joined 9. Justice Barrett joined 5 dissents, Justice Kavanaugh joined 3, and Chief Justice Roberts joined none, reflecting their preference for majority coalitions. A final note on the disposition outcomes. As I just mentioned, the Supreme Court reversed, vacated, or remanded an overwhelming 70% of the cases that came before it. This high reversal rate reflects the court's approach to case selection. The justices choose which cases to hear from thousands of petitions, typically granting review when they believe correction is needed. So while a 70% reversal rate might seem dramatic, it actually demonstrates that the court is strategically targeting cases where they disagree with lower court outcomes. The pattern has important practical implications for lawyers and litigants. If the Supreme Court grants your petition for review, the data suggests you have a strong chance of success if you are the party seeking reversal. For parties defending lower court victories, Supreme Court review often signals trouble ahead. This creates a distinctive dynamic where getting the court's attention is simultaneously the best and worst thing that can happen to your case, depending on which side you represent. The case selection approach highlights the court's belief that its role should function as an error correction mechanism for the federal judiciary. Rather than randomly sampling lower court decisions, the justices focus their limited time on cases where they believe course correction is necessary. This selective approach means that Supreme Court review functions less like an appeal and more like a targeted intervention in areas where the justices see problems with current legal interpretations. Now I want to take a deep dive into Trump versus CASA. What struck me most about Justice Barrett's majority opinion in Trump versus CASA was her tremendous reliance on historical sources rather than textual analysis. Barrett cited English legal treatises from the 1800s, examined chancery practice dating back centuries, referenced American equity decisions from the 1800s and early 1900s, and even invoked Blackstone's commentaries. She delved into the judicial prerogative of the king, analyzed the evolution of English equity courts, and traced the absence of universal injunctions through multiple historical periods. This extensive historical excavation stood in striking contrast to the minimal attention paid to the actual text of the Judiciary Act itself. For a justice known as a textualist, the disproportion was remarkable. Pages of historical analysis flowing from just 4 words of statutory text. That methodological choice seemed significant enough to warrant deeper examination. The Trump versus CASA case presents a fascinating study in judicial methodology, particularly in how justices approach statutory interpretation when the text provides minimal guidance. The dispute centered on Section 11 of the Judiciary Act of 1789, which grants federal courts jurisdiction over all suits. In equity, that's it. Just those 4 words about equity jurisdiction. The sparse nature of this text created an interpretive vacuum. Congress didn't define what equity meant, didn't list specific remedies courts could grant, and certainly didn't mention universal injunctions. This absence of detail forced each justice to develop a framework for determining what equitable powers federal courts actually possess. Justice Barrett's majority opinion filled this void through historical originalism. She applied the test from Grupo Mexicano, which requires that equitable remedies be sufficiently analogous to relief available in the High Court of Chancery in England at the time of the Constitution and the original Judiciary Act. Barrett conducted an extensive historical survey examining English chancery practice, early American equity decisions, and 19th century Supreme Court precedents. She concluded that because universal injunctions were conspicuously non-existent for most of our nation's history and had no analog in founding-era English practice, they exceeded federal courts' statutory authority. Justice Sotomayor's principal dissent took a fundamentally different approach to the same textual silence. Rather than looking backward to historical practice, she focused on equity's defining characteristic, adaptability. Sotomayor argued that the Judiciary Act of 1789 codified equity itself, not merely a static list of remedies. She emphasized that historically, equity courts constantly declined to lay down any rule which shall limit their power and discretion, and that it was impossible to foresee all the exigencies of society which may require their aid and assistance. In her view, Congress's choice to use the broad term equity rather than listing specific remedies demonstrated an intent to preserve equity's flexible nature. Justice Jackson's separate dissent emphasized what she called equity's essential adaptation to modern governance. She argued that the rise of universal injunctions represented equity responding to new governmental structures and expanded federal authority that didn't exist at the founding. Each approach reflects a different theory about how to interpret broad statutory grants of power. Barrett treated the textual silence as requiring historical constraint. Equity power should be limited to what existed in 1789. The dissents treated the same silence as preserving equity's traditional flexibility. Congress chose broad language precisely to allow adaptation to new circumstances. The Judiciary Act's 4-word grant of equity jurisdiction thus became the foundation for a fundamental disagreement about the nature of judicial power itself. This methodological choice becomes even more striking when compared to Barrett's approach in other cases this term. In most statutory interpretation cases, Barrett acts as a conventional textualist. In Esteras v. United States, a criminal sentencing case, Barrett applied pure textual analysis using the expressio unius est exclusio alterius canon. When Congress listed 8 specific sentencing factors in Section 3, 583A, but omitted the retribution factor from Section 3, 553A2A, she concluded the omission was intentional. No dictionary consultation, no historical analysis, just straightforward structural interpretation of what Congress included versus excluded. In Medical Marijuana v. Horn, Barrett conducted her most extensive dictionary work of the term. She consulted multiple sources to analyze injured in his business or property. The American Heritage Dictionary for ordinary meanings, Ballantyne's Law, Dictionary for Legal Definitions, Black's Law Dictionary for specialized meanings, and multiple editions of Webster's Dictionary spanning decades. Barrett used these contemporary legal tools as her primary interpretive framework, writing that, When a word carries both an ordinary and specialized meaning, context determines the choice between them and delivering her memorable line. It is hard to make a term of art argument without the term of art. In CASA versus United States, the wire fraud case, Barrett again relied heavily on dictionary definitions to interpret obtain, consulting Webster's Third International Dictionary to establish that something is obtained regardless of equal value exchanged. She also applied the old soil principle, examining common law fraud's historical meaning, but notably used this historical analysis to support rather than replace her textual interpretation. In FDA versus R.J. Reynolds, facing the ambiguous administrative law term adversely affected, Barrett treated it as a contemporary term of art with a long history in federal administrative law. Rather than seeking founding-era meanings, she analyzed how modern courts have interpreted similar language in the Administrative Procedure Act and other statutes, emphasizing that variations of adversely affected appear in 124 current federal statutes. The striking contrast, Trump versus CASA, breaks this pattern entirely. Barrett never consulted dictionaries to determine what equity meant in 1789 or how founding-era legal sources defined equity jurisdiction. She didn't ask whether equity had an ordinary versus specialized meaning or whether contemporary legal usage provided guidance. Instead, she immediately made 1789 English Chancery practice the decisive interpretive framework. Where her other opinions this term used text plus contemporary legal context, Trump versus CASA used minimal text plus historical constraint as determinative. The methodological disparity is quantifiable. Barrett's other major opinions this term cite dozens of dictionary definitions and contemporary legal sources, while Trump versus CASA cites 0 dictionaries and relies almost exclusively on 18th and 19th century English legal treatises. For a justice who typically begins statutory interpretation with Webster's and Ballantyne's, this represents a complete methodological departure. What do you all think about this different methodology? Could it be that due to reliance on the methodology stated in Grupo Mexicano? To understand Barrett's methodological choice, we need to examine the Grupo Mexicano decision that she relied upon so heavily. In that 1999 case, the court established a strict historical test for determining federal courts' equitable powers under the Judiciary Act of 1789. The dispute involved creditors seeking a preliminary injunction to freeze a debtor's assets before obtaining a judgment, essentially asking for a remedy that would prevent the defendant from moving money while litigation was pending. Justice Scalia's majority opinion rejected this request by applying what became known as the Grupo Mexicano test. Federal courts can only exercise equitable remedies that are sufficiently analogous to relief available in the English High Court of Chancery at the time of the Constitution's adoption and the original Judiciary Act. Scalia emphasized that federal equity jurisdiction is limited to the principles of the system of judicial remedies which had been devised and was being administered by the English Court of Chancery at the time of the separation of the two countries. The court concluded that since English courts didn't provide asset freezing injunctions until 1975, centuries after the founding, American federal courts lacked authority to grant such relief. Critically, Grupo Mexicano rejected what Justice Ginsburg's partial dissent called a dynamic equity jurisprudence that would allow courts to adapt equitable remedies to modern circumstances. Instead, it anchored federal equity power firmly in 18th century English practice, requiring courts to find historical analogs rather than innovate new remedies. This explains Barrett's approach in Trump versus CASA. Once she determined that Grupo Mexicano controlled, and universal injunctions lacked sufficient founding-era precedent, her conclusion became almost inevitable. Grupo Mexicano essentially mandated the historical methodology that Barrett employed, making originalist excavation not just preferred but legally required under existing precedent. But Barrett's application represents a significant extension of Grupo Mexicano's reach. The 1999 case involved private parties and prejudgment asset freezes, a relatively narrow commercial dispute. Barrett extended the same historical constraint approach to universal injunctions against government action, transforming Grupo Mexicano from a commercial law precedent into a constitutional structure principle that limits federal courts' power to check executive overreach. This extension is precedentially defensible. She faithfully applied Grupo Mexicano's methodology, but constitutionally controversial, as it constrains judicial authority and separation of powers conflicts, where courts have traditionally served as the final check on executive lawlessness. Barrett's questioning during oral argument telegraphed exactly how she would approach the case. When it came time for her questions, she immediately zeroed in on history. I have a question about the history. So Grupo tells us that we have to look back to 1789 and the High Court of Chancery. She then posed the critical challenge that would define her majority opinion. What do you think is your very best example of something that would look at the period that Grupo tells us is relevant, that would support something that looks like universal relief? The liberal dissents, a frontal assault on Grupo Mexicano. The liberal justices didn't just disagree with Barrett's conclusion, they launched a sophisticated attack on the entire Grupo Mexicano framework itself. Justice Sotomayor delivered the most direct critique of Barrett's historical methodology. She argued that Grupo Mexicano does not dictate the level of generality for that historical inquiry, contending that Barrett applied the historical test far too rigidly. While Sotomayor accepted that some historical analysis was required, she rejected Barrett's demand for such a specific historical match. Her most memorable accusation was that the majority fundamentally misunderstands the nature of equity by freezing in amber the precise remedies available at the time of the Judiciary Act. This "frozen in amber" phrase became her signature attack on Barrett's approach. Sotomayor emphasized that adaptability has thus always been at equity's core, and that equity courts constantly decline to lay down any rule which shall limit their power and discretion. In Sotomayor's view, the Judiciary Act of 1789 codified equity itself, not merely a static list of remedies. She argued that Congress chose broad language precisely to preserve equity's flexible nature, allowing courts to adapt to circumstances the founders couldn't foresee. Sotomayor then delivered a devastating blow to Barrett's logic. She pointed out that under Barrett's rigid Grupo Mexicano test, even plaintiff protective injunctions against patently unlawful government action should be impermissible. Why? Because ex parte Young injunctions, which everyone agrees are valid, find no analog in the relief exercised in the English Court of Chancery, which could not enjoin the Crown or English officers. If Barrett's historical test were truly consistent, it would eliminate remedies that the court has used for over a century. Justice Jackson took a different but equally powerful approach. Rather than attacking the historical methodology directly, she focused on its constitutional consequences. Jackson argued that applying Grupo Mexicano to universal injunctions creates a zone of lawlessness within which the executive has the prerogative to take or leave the law as it wishes. Her critique centered on constitutional structure. Jackson emphasized that what it means to have a system of government that is bounded by law is that everyone is constrained by the law, no exceptions. In her view, Grupo Mexicano's historical test, when extended to executive power cases, fundamentally undermines the principle that courts must have authority to order everyone, including the executive, to follow the law. Barrett responded to these attacks, but in ways that revealed the tension in her position. She acknowledged that equity is flexible, but insisted that its flexibility is confined within the broad boundaries of traditional equitable relief. She maintained that a modern device need not have an exact historical match, but under Grupo Mexicano, it must have a founding-era antecedent. Most tellingly, Barrett relegated Sotomayor's entire approach to a footnote, dismissing it as aligned with Justice Ginsburg's partial dissent in Grupo Mexicano, which eschews the governing historical approach in favor of a dynamic equity jurisprudence. This revealed that Barrett saw the case as a choice between historical constraint and judicial innovation, and she chose constraint. The dissents expose a fundamental disagreement about Grupo Mexicano's proper scope. Barrett treated it as requiring historical constraint in all equity cases. Sotomayor argued it allows flexible historical inquiry and shouldn't freeze equity in 1789. Jackson contended that Grupo Mexicano's historical test creates constitutional problems when applied to separation of powers cases. This wasn't just a disagreement about universal injunctions, it was a battle over the entire framework for interpreting federal equity power, with implications extending far beyond this single case. The Grupo Mexicano battle lines, how oral arguments previewed the split. Barrett's questioning during oral argument telegraphed exactly how she would approach the case. When it came time for her questions, she immediately zeroed in on history. I have a question about the history. So Grupo tells us that we have to look back to 1789 and the High Court of Chancery. She then posed the critical challenge that would define her majority opinion. What do you think is your very best example of something that would look at the period that Grupo tells us is relevant, that would support something that looks like universal relief? Notice the language. Grupo tells us that we have to. Barrett treated Grupo Mexicano as mandating the historical approach. This wasn't a neutral inquiry, it was a test. Barrett was essentially saying, Grupo Mexicano requires founding-era analogs, so show me your best shot. When the Respondents' Council offered Bills of Peace as their best historical example, Barrett immediately began picking it apart. She questioned whether these were really analogous to universal injunctions or just early class actions. She acknowledged the need for analogical reasoning, but expressed concern about stretching too far from what she called party-centric history. Her skepticism was palpable. I think the problem is when we have such a party-centric history, if it has to be reasoning that fits within the confines, then I think we have a little bit of trouble. What's remarkable is that 100% of Barrett's substantive questions to the respondents focused on this Grupo Mexicano historical test. She spent her entire questioning time probing the 1789 English Chancery precedent. To the government, she asked about practical enforcement issues, but when addressing the core legal question, it was all about what English chancellors did centuries ago. 0 questions focused on the actual statutory text of the Judiciary Act itself. For Barrett, Grupo Mexicano had already answered the methodological question. Only historical analogies mattered. The liberal justices, Grupo Mexicano as constraint, not gospel. The liberal justices took a fundamentally different approach during oral argument, one that would later manifest in their dissenting opinions. They acknowledged Grupo Mexicano existed, but refused to let it dominate their analysis. Justice Sotomayor made some reference to history, but used it tactically rather than as a foundational framework. When she asked, "We've had universal injunctions in some form, correct, since the founding?" and cited cases like Pierce versus Society of Sisters from 1925, she was marshaling historical evidence to counter the government's claims, not conducting the kind of deep historical excavation that defined Barrett's approach. For Sotomayor, history was ammunition, not methodology. Instead, Sotomayor focused primarily on practical implementation and modern equitable doctrine. She pressed hard on the winter factors analysis, asking how courts could separate that out and say the keystone of whether you're entitled to universal injunction is the only merits question, because the other factors are not eliminated by winter. She explored class action alternatives and expressed urgency about thousands of children who are going to be born without citizenship papers. When she challenged the government with extreme hypotheticals about stopping a clearly, indisputably unconstitutional act, taking every gun from every citizen, she was probing the practical consequences of limiting judicial power, not the historical pedigree of particular remedies. Justice Jackson's questioning was even more striking in its contrast to Barrett's historical focus. Jackson asked only one substantive question during the entire argument, and it was entirely procedural: whether courts would have to peek at the merits while the merits are being litigated when deciding preliminary injunction requests. Her question focused entirely on procedural mechanics, 0% historical analysis. The methodological preview. The battle lines were drawn before the first question was asked, and the oral argument simply revealed how far apart the justices were on this fundamental question of judicial methodology. The contrast reveals 2 completely different theories of judicial interpretation, one that looks backward to constrain judicial power, and another that looks forward to ensure law can adapt to new circumstances. Trump versus CASA offers us a window into something much larger than universal injunctions. It reveals how methodological choices, the tools justices use to interpret law, can determine outcomes in the most consequential cases. Barrett's extension of Grupo Mexicano from commercial disputes to separation of powers conflicts shows how precedent can be stretched to serve new purposes, even when that stretching fundamentally alters the balance of constitutional power. The case also demonstrates how the court's conservative majority approaches executive authority. By eliminating universal injunctions, they've created what Justice Jackson called a zone of lawlessness, where courts cannot fully enforce constitutional limits on presidential power. Whether you see this as necessary constraint on judicial overreach or dangerous erosion of constitutional checks depends entirely on your view of how our system should work when the stakes are highest. But perhaps, most importantly, Trump versus CASA reveals the methodological flexibility that even the most committed textualists employ when the law demands it. Barrett's willingness to abandon her usual dictionary-heavy approach for pure historical analysis shows that judicial methodology isn't as rigid as we might think. Justices choose their interpretive tools, and those choices shape our constitutional order in profound ways. That was my deep dive into Trump versus CASA. I hope you all found this insights worthwhile. Now let's talk about the June 30th, 2025 order list. In this list, the Supreme Court agreed to hear ad cases. Let's start with M&K Employee Solutions versus the IAM National Pension Fund. In this case, the court granted certiorari to resolve a circuit split over when pension plan actuaries must select the assumptions they use to calculate withdrawal liability under ERISA. The dispute centers on whether actuaries must lock in their assumptions by the measurement date, the last day of the plan year before an employer withdraws, or whether they can select different assumptions afterward based on more complete information. The petitioners argue that calculating liability as of the measurement date requires using assumptions the actuary actually endorsed on that date, while respondents contend that forcing premature assumption selection conflicts with ERISA's requirement that actuaries provide their best estimate of plan experience. This case affects 1,400 multi-employer pension plans covering 11 million workers, fundamentally altering how pension professionals must balance legal compliance with actuarial best practices. Let's talk now about Cox Communications versus Sony Music Entertainment. The question in this case is whether internet service providers can be held liable for materially contributing to copyright infringement simply by continuing to provide service to customers they know are pirating music, without proof that the provider actively encouraged or intended to promote the illegal activity. Sony and other major record labels sued Cox for $1 billion after Cox failed to terminate internet service to repeat infringers, despite receiving over 160,000 automated piracy notices. Cox argues that the Fourth Circuit created a dangerous new standard, forcing internet providers to cut off service based on unverified bot-generated notices or face-crushing liability, even when they took steps to discourage piracy and gained no profit from it. The case also involves when defendants face enhanced penalties. Cox was hit with damages up to $150,000 per song instead of the usual $30,000 because a jury found Cox acted willfully based solely on knowing that customers were infringing. The U.S. government sided with Cox, arguing that internet providers shouldn't be liable for merely failing to terminate customers without affirmative misconduct, and that willfulness should require knowing your own conduct is illegal, not just knowing others are breaking the law. Cox warns that a ruling against them would force mass disconnections of innocent users. Entire families, hospitals, and universities could lose internet access because someone on their shared connection allegedly pirated music. The stakes are enormous. The ruling could either force hair-trigger disconnection policies nationwide or significantly limit how copyright holders can combat online piracy. Let's move next to FS Credit versus Saba Capital Master Fund, a case that asks whether parties can sue to cancel contracts that allegedly violate the Investment Company Act, even though Congress never explicitly created such a right to sue. The case pits long-term investment funds against Saba, an activist investor that buys discounted fund shares and then pressures funds to make changes so Saba can flip them for quick profits. The funds adopted control share provisions to limit Saba's voting power, and Saba sued to get those provisions thrown out. The funds argue that courts can't create private lawsuits that Congress didn't authorize, pointing out that Congress gave the SEC broad enforcement powers and created an explicit private right of action elsewhere in the same law for fiduciary duty breaches. Saba counters that the statute's language allowing courts to grant rescission at the instance of any party necessarily means parties can file lawsuits, and that this reading is supported by a 1979 Supreme Court case involving similar language. The circuit courts are split 2-1, with only the Second Circuit recognizing this private right of action, while the Third, Fourth, and Ninth Circuits have rejected it, creating a situation where the same lawsuit would be dismissed in most circuits, but can succeed in the Second Circuit, where many investment companies can be sued. Just last week, the Supreme Court decided Medina versus Planned Parenthood, which rejected a private right of action under Medicaid using virtually identical reasoning that the funds advance here. The court found that federal statutes need clear and unambiguous rights-creating language, and that spending power statutes are especially unlikely to confer private enforcement rights, suggesting the court will likely rule for the investment funds and eliminate this private cause of action. Let's now cover Enbridge Energy versus Nestle. This case asks whether federal courts can excuse the strict 30-day deadline for moving a case from state to federal court when there are exceptional circumstances, or whether missing that deadline by even 1 day means you're stuck in state court forever. Michigan's Attorney General sued Enbridge to shut down the Line 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, And while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits of Mackinac, and while Enbridge could have moved the 5 oil pipeline that runs under the Straits case to federal court immediately, the company chose to fight in state court for over 2 years before finally trying to remove the case 887 days after the deadline. Enbridge argues that exceptional circumstances, including Canada invoking an international treaty and substantial federal issues involving pipeline safety and foreign affairs, should allow federal courts to excuse the late removal, while Michigan argues that the 30-day deadline is absolute and that allowing exceptions would undermine state courts' authority. The federal appeals courts are split on this issue, with some circuits allowing equitable exceptions in rare cases, while others, including the Sixth Circuit here, hold that missing the deadline by even a day requires the case to go back to state court, regardless of how important the federal issues might be. The court also agreed to hear Humberto Urias Orellana et al. Versus Bondi. The briefs were submitted in paper format and not uploaded, so I haven't yet been able to read them. When I do, I'll of course update you all. Second to last case is Rico versus United States, which asks whether courts can pause the clock on supervised release when a defendant goes missing, then hold them accountable for crimes committed after their supervision was supposed to end. Isabel Rico was on federal supervised release that was scheduled to expire in June 2021, but she disappeared in 2018 after failing to report to her probation officer. Then in January 2022, 6 months after her supervision should have ended, she was caught dealing fentanyl. The government argues that Rico's supervised release was told or paused while she was a fugitive, meaning she was still technically under supervision when she committed the 2022 drug offense, which allowed them to give her a much harsher sentence of 16 months instead of the 8 to 14 months she would have faced for just the earlier violations. RICO counters that there's no law allowing courts to pause supervised release for fugitives, and that the government's position creates an impossible situation where she's somehow both on and off supervision at the same time. The federal appeals courts are split 6-2 on this issue, with most circuits allowing this fugitive tolling, while the 1st and 11th circuits have rejected it as having no basis in federal law. Last case is Senate Committee on Ethics versus Federal Election Commission. Last case is Senate Committee on Ethics versus Federal Election Commission. This is a possible groundbreaking campaign finance case that could blow up the rules governing how political parties spend money to get their candidates elected. The Republican Party committees basically asked the court to strike down federal limits on coordinated party expenditures, essentially caps on how much parties can spend when they're working directly with their candidates, rather than going it alone. Here's a twist. The Solicitor General sided with the Republicans and refuses to defend a law the government defended for decades. After this move, the DNC asked the Supreme Court to join in the case to more or less become the defendants and fight this battle themselves. The Democrats make a classic follow the money argument. They claim unlimited coordinated spending would create a massive loophole allowing wealthy donors to buy influence by pumping unlimited cash to candidates through political parties. The Republicans counter that these limits violate core First Amendment rights by building an artificial wall between parties and their own candidates. Imagine forcing a football coach to call plays without talking to the quarterback. With both parties now locked in direct combat and the government sitting on the sidelines, this case has all the makings of a Supreme Court showdown that could fundamentally reshape American campaign finance. The decision, expected by summer 2026, could either preserve 50 years of anti-corruption law or unleash a flood of new money into politics just in time for the 2028 elections. Those were summaries of the 7 cases the Supreme Court agreed to hear, and collectively, they reveal a court poised to make sweeping changes from billion-dollar copyright battles that could reshape internet access to campaign finance disputes that may determine who controls political spending. What's particularly striking is how many cases reflect the court's ongoing skepticism toward private lawsuits under federal statutes, a trend that could fundamentally alter how Americans enforce their rights across multiple areas of law. These cases promise rulings that will reverberate far beyond the legal world, defining our digital economy, political system, and justice framework for years to come. The summer recess gives us time to process this blockbuster term, but the court's work continues. I expect we'll see an order list this Thursday. If anything notable emerges, I'll update you with a dedicated episode. I plan to release episodes during the summer with more analysis as the justices' decisions continue reshaping American law in ways that will define our legal landscape for years to come. Please also note that I'm working to add earlier cases to the podcast. I want to thank everyone who has been following, commenting, and listening. I started this podcast less than 3 months ago, right in the middle of this incredible term. I've been figuring things out along the way, and I'm grateful you've stuck with me as I've worked to bring thoughtful analysis to people who care about how the Supreme Court really works. And stick around, because I have big plans for the podcast this fall. I'm still working through the details and don't want to share specifics yet, but let's just say I'm excited to make the show even better for all of you. Talk to you soon.